The question now is that Part 3 is amended to stand part. Those of that opinion will say aye. Those against no. Part 3 will, as amended, will stand part. The question now is we now come now to Part 4, the debate clauses 46 to 96 and Part 1 of Schedule 3. The Honourable Christopher Finlayson.
I didn't think anyone would allow this part to go through on a nod, because it's a very important part and it's at the heart of the legislation, and it's only fair for members of the committee if I say a few words, and then I expect that there will be quite a lot of discussion. The first point relates to the authorising minister, and I recall Mr Little raising in his first reading speech the appropriateness of the relevant minister for warranting purposes being the Attorney-General, which is what the reviewers had proposed, or whether it should be the ministers in charge of the agencies. And that got me thinking. I think it got the Select Committee thinking, and the conclusion of the Select Committee as a result of hearing those kinds of arguments, and also having heard from the Inspector General, was that the Attorney should not be the person who does the authorising, but it should be the Commissioner of Warrants and the Minister in charge of the agency. And having reflected on it, I totally agree with the Select Committee and think I was wrong to have moved on the reviewer's recommendation. And one of the reasons I say that is because it's the Minister responsible for the agency who issues the ministerial policy statements. So I would have thought it was very important for that Minister also to be involved in, if you like, in the everyday activity of a minister responsible for the agencies, namely dealing with warrants. And in any event, the Attorney-General should be remote from a lot of the warranting stuff, and the Attorney-General's concerned to stand back and make sure the business of government is conducted in accordance with the rule of law, and should not really be at the coalface on this sort of matter. So I'm very happy to accept that recommendation and think it's absolutely correct. Can I say something about Part 4,
Yes.
Which I've already been talking about? It contains the authorisation regime, and it provides lawful authority, the very thing that the committee's been talking about off and on throughout the afternoon and the evening, for the carrying out of otherwise unlawful activities, and it confers on the agency's power to give effect to authorisations granted under this part. There are a number of changes to Part 4 that the Select Committee has made, and we accept all of them. It's provided, because I think these have provided for the opportunity to reorganise Part 4 to make it much clearer the nature of the powers conferred on the agencies and the circumstances in which they apply. And it's interesting to note the committee went through all classes of warrants, and some unnecessary powers have been removed or limited. Let me give the committee an example of where the committee, I think, has done really good work. The bill has introduced provided for purpose-based warrants, and this would have enabled the issue of a warrant without any need to specify the persons in respect of whom or the places at which activities would be carried out. The committee's recommended removal of purpose-based warrants on the basis that class-based warrants are available under the intelligence warrant regime and will meet the operational needs of the agencies while still requiring greater specificity than purpose-based warrants would have. And I agree with that, and I think that that is going to encourage much better oversight of and more effective oversight of activities. The second point I want to make concerns the enhanced protections in the warranting system. For example, clauses 53 and 57. Clause 53, this requirement of due particularity in warrant applications. So an application for an intelligence warrant has to be in writing, obviously, amongst other things, set out the detail of the activity proposed to be authorised by the warrant and the grounds why the application is made, including the reasons why the legal requirements have been met. And that's an example of the specificity that is required in the warranting system. And secondly, I refer members to clause 57, dealing with the additional criteria for the issue of an intelligence warrant. A new criterion has been added to the matters that the Minister and in the case of a Type 1 warrant, the Commissioner must be satisfied of before issuing a warrant, and that's that all reasonably practicable steps will be taken to minimise the impact of the proposed activity on members of the public. Mr. Chair.
The Honourable Chris Finlayson.
And then I refer honourable members to clause 67, and that the protections for privilege now cover, you can see the underlined phrase, privileged information as well as privileged communications, and provide protection for settlement negotiations and mediations as recognised in the Evidence Act 2006. Can I just then refer to the rewording of certain key provisions in the warranting regime so as better to reflect the purpose and the nature of the activity being authorised. The removal of the training and testing warrants from the intelligence warrant regime in, I think it's subpart 1 of part 4, has enabled some wording changes to key provisions so that the language used better reflects the nature and the purpose of proposed activities. So we now, Type 1 warrants now authorise otherwise unlawful activity, quote, for the purpose of collecting information about or to do any other thing directly in a relation to a New Zealand citizen or permanent resident. And as we know, Type 2 warrants authorise the carrying out of otherwise unlawful activity for the purpose of collecting information or to do any other thing in circumstances where a Type 1 warrant is not required. The language that I've just quoted of doing any other thing directly in relation to is intended primarily to cover GCSB cyber protection activities where the person is not collecting information about the New Zealand person, but doing so is the inevitable result. Then the third point I want to make concerns the relation, or the creation, I should say, of standalone regimes for each different category of warrant. Training and testing activities were provided for in the bill at introduction as a purpose for which an intelligence warrant could be obtained, and this led to difficulties in framing and drafting some of the warranting provisions in order to accommodate these purposes. A number of submitters were also concerned about the scope of these new type of training and testing warrants. Accordingly, training and testing activities are now separately dealt with in a standalone regime in subpart 3A of part 4, and they are the warrants which are called practice warrants. As part of the separation of practice warrants from the intelligence warrants regime, the safeguards from the intelligence warrant regime have been replicated, but it's important to note some additional ones have been added. All practice warrants are subject to the triple lock regardless of the nationality of those who may be affected by the activities, and there's mandatory reporting on the conduct of the activities under a practice warrant, and reporting both to the Minister and to the Inspector General. There are just a couple of other points I want to make about the further limiting of practice and removal warrants. It's important to note that the activities able to be exercised under a practice warrant have been constrained on the recommendation of the Select Committee. Human intelligence activities and the NZSIS's power of entry are not available under a practice warrant. Removal warrants have also been limited in their application. At introduction, the bill would have enabled the GCSB to obtain a removal warrant and give effect to it. This would have conferred a power of entry on the GCSB to retrieve devices. in contrast to the situation with intelligence warrants where the GCSB has an obligation to work with the SIS to access powers of entry. The Select Committee recommended removal warrants be limited to the SIS only, and where the GCSB requires removal of a device from private premises or property, the SIS will apply for a removal warrant and will carry out that removal on behalf of the GCSB. There are a couple of terminology changes. The term information's been substituted for intelligence in a number of places in Part 4. And as I said, I think Part 4 is now better organised. Can I simply refer finally to the... Mr Chair? I anticipated the bill.
Yes. We'll let the Minister run.
Right.
No matter the normal two-call rule.
Okay.
The Honourable Minister.
Thank you, sir. The only other point I was going to make related to the Labour Party's, the proposal about increasing this is in clause 47, raising the threshold for serious crime and type 1 warrants from any offence punishable by 2 or more years imprisonment to any offence punishable by 3 or more years, and that change only applies in the context of type 1 warrants, not to serious crime in the context of incidentally obtained information. So Mr Parker suggested that to me a few days ago, gone away and thought about it, happy to go along with that.
The Honourable David Parker.